You might be learning different laws based on the course that you are doing, and now you are here to learn interpretation of statutes. And when you start studying this particular subject, you might be thinking that a judge will interpret or construct in every single judgment. If you are thinking so, you are wrong. It is neither appreciated nor required to interpret or construct in every single judgment. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of interpretation of statutes, today I am going to give few additional definitions on the meaning of statutes, and then we will also discuss how the statutes are made, and finally we will also learn why to study the process of lawmaking. Why interpretation or construction should not be the first thought? Because there is a lot of work gone behind before a law comes into force, and finally a law comes in front of the court. A court should not start doing interpretation or construction unless and until it is really required. It should be the last resort, and to understand that, we should know how exactly laws are made, what are the different steps that we are taking before making the law, and then we will also understand what are the processes. To understand that, let's get into the first slide. Meaning of the term statute. We have already discussed once when we discussed the meaning and definition of interpretation, statutes, and then interpretation of statutes together. However, I got two definitions here, so thought of sharing it again. First thing first, what is the origin of the word statute? It is coming from the word statutum, and it is believed that King Henry III was the first one to use this particular term. What is the simple meaning of term statutes? Statutes are written law passed by a legislative body. Here we need to observe two important things. One, it is in written form. Two, who is passing them? The legislative body passes them. And when we are saying legislative body, it can be in different way. That is why I have put a law made by sovereigns are called statutes. Coming to the definitions part, the first one is coming from Bowery's Law Dictionary, which says a statute is a law established by the act of the legislative power, that is, an act of the legislature. The term statute is generally applied to laws and regulations of every sort of law which ordains, permits, or prohibits anything which is designated as a statute without considering from what source it arises. He says laws and regulations can be considered as statute, or dictionary says the statutes can be laws or regulation, and it can permit few things and prohibit something. Like for example, in Transfer of Property Act, it is discusses about how exactly transfer is made, or Indian Penal Code, it prohibits certain crimes like you should not do this. Likewise, it either permits or prohibits. That's what discussed in this particular dictionary. Coming to the definition from Maxwell, he keeps it very easy. He says the will of the legislature is called statutes. As far as Indian context is concerned, we are not calling it as statutes, rather we are calling it as laws, which is first defined under Article 13 of the Indian Constitution. Not defined, it is used. Now that is how we have to understand the meaning of term statutes. Laws how made in India. Now this is one beautiful topic from Indian Constitution which needs at least 3 hours to understand the entire concept. But I will spend about 3 minutes to explain this entire slide, as we have to quickly move on. Now, as I have already told, in India we are calling them as laws but not statutes, and this you can see in Article 13. Now, if you go to part 11 of Indian Constitution, that discusses about relations between the union and the states, and there under chapter 1 we are discussing the legislative relations. There we can see distribution of legislative powers between Article 245 to 255, and the specific article, that is Article 246, discusses about subject matter of laws made by Parliament and by the legislatures of states, Now when I say parliament, it is central government and legislatures of states. Now what are the subjects matter distributed between central and state? To understand that, we need to go to 7th schedule. When you go to 7th schedule, you will see 3 different lists. List 1, list 2 and list 3. List 1 discusses about union list, list 2 is state list and list 3 is concurrent list. List 1 is the power on which the central government has power to make the laws, whereas list 2 discusses about the state on which topic it can make laws, and list 3 is about those topics on which both union as well as state or both central as well as state can make laws. Originally under list 1 there were 97 topics, but as of now we have 100 topics, and under list 2 we had originally 66 topics, but now we have 61 topics, and under list 3 we had originally 47 topics and now we have 52 topics. Between list 2 and list 3, the 5 topics that were under state list are now being to concurrent list. That means both state and central have the power over them, and I have given the list which are being shifted from list 2 to list 3 from the 42nd Amendment Act 1976. As far as list 1 is concerned, I have also given what are the addition and deletion there. You can see the immediate box. Now with this list, both central as well as states are making laws. There are again procedures like first reading, second reading and the third and final reading and taking votes in upper house, lower house, all of that is there. And after completing everything, a law come to force. And if a judge start doing interpretation and construction for every single aspect, that is not okay. Only when it is not satisfying the requirement of the intention of the author, the question of interpretation or construction comes into picture. This is about how central or state governments are making statutes or laws. Now coming to the interesting part, that is Article 123 and Article 213, which are discussing about power of president to promulgate ordinance and power of governors to promulgate ordinance respectively. Here when the session is not on and if there is a requirement, the president or the governors can release ordinance under Article 123 for the president and under Article 213 from the governors. That is also possible. But then when the session starts within 6 weeks, the same either need to be passed or need to be declined. That is again a procedure, but this is the way how a law comes into force. You might be thinking that why should we know this, or what is the necessity of knowing all of this? Remember, lawmaking is the right and responsibility of the legislature. It is making law with so many steps. And then once the law is out, if there is any breach or if there are any questions, the court's duty is to find answer with the help of the statutes available. That is the duty of the court. Court is not there to interpret or construct on every single law. Only when court feels that a particular statute is not reaching the intention of the author, or when there is ambiguity, or when there is lack of clarity to reach the intention of the author, courts can interpret or construct. That is the last option the court should get into. Now, while we are thinking of interpreting or constructing, other than laws, we should also remember many things. Like if we have a question, the first thing that we should try to do is read the entire law and try to find the answer. If the judge is not getting the answer even after reading the entire law, now in my next session I am going to teach you how to read a particular law. what are the different parts of law that we are going to understand in my next presentation. And a judge should try to read the entire law and then try to understand it and try to give life to the judgment. Even then, after reading the entire law, if he is unable to understand the meaning, in that case, the judge should try to understand the parliamentary proceedings. What happened when a bill was discussed on this particular law? What are the different opinions made by different people in the parliamentary proceedings? All of that need to be studied. Sometimes courts should go beyond also to understand what lawmaking committees or their reports said. That is also very important. Like for example, when I was discussing about CRPC, somewhere I referred about Malimat report, where lot of suggestions came to increase the fines and also give compensation to the victims. Now, this is what we are seeing in recent days. Compensation to the victims. Earlier, there were not so much of compensation, but now we are seeing compensation to the victims. Now, how it is coming? It is coming from Malimat report. We have to go back and see what was the suggestion by the committees and how exactly it came to parliament and what were the different discussion and then how exactly this law came into force. We have to see all of them to find the answer. Like for example, when we are discussing about the mischief rule or the Hayden's rule, we will even try to understand what was the mischief happened during that time and how exactly a cure was tried to bring. Now all of that need to be studied by the court before getting into interpretation or construction. Of course, mischief rule is a rule for interpretation and construction, but before getting into interpretation or construction, the court should try to read the intention of the author and try to give life and force to the law. That should be the approach, and only as a last resort, court should get into or the judge should get into interpretation or construction.
When you are learning something, don't differentiate small and big.